All right, good afternoon, all of our listeners. We're so happy to be here today. I'm Barbara Jennings with Towne Benefits, and with me is Corbin Granger. Corbin, would you like to say hello, Corbin?
Hello, Corbin.
Thank you, appreciate that. And so, again, we're happy to be here. It's a lovely afternoon, and we have some information that we hope you will find helpful. We're going to try to entertain a little as well as educate. Today, we're talking about the end of COVID-19. All these health emergencies that we've been going through. Hard to believe for me that it's been 3 years, but it has been 3 years. It seems like only yesterday I'm walking through Kroger, looking at empty shelves and asking if I can buy more than one pack of chicken and that sort of thing. And 3 years later, here we are. We're wrapping things up. And I don't know where those 3 years have gone, but it's been interesting to say the least. Now I am going to show you our disclaimer. My apologies, there we go. Got to get my hand and my mouse working together as one. All right, our disclaimer. We are not lawyers and we're not tax advisors. And so whatever information we're sharing with you today is for your education, and it is not legal or tax advice. There are going to be times when you may need to consult tax folks or legal folks in order to get help, and please don't ever hesitate to do that. This presentation is a broad overview of COVID-19 and the related plan changes and compliance information. And it seems like this has been kind of an ever morphing situation literally for the last 3 years. And so we've done our best to assemble information that is accurate as far as we know as of today, but some of the stuff can change, and they can change with fairly short notice. Now, I'm an HR consultant with Towne Benefits, and I probably talk to some of you all on a regular basis or from time to time. And Corbin, how about you? What are you up to here at Towne Benefits?
Yes, so I'm really the compliance officer, so I handle a lot of the benefits issues, or HIPAA, ERISA, Section 125. So I think together we make a really good team. We try to hit both sides of what employers are struggling with today, because it's not just benefits and it's not just HR, it's a combination.
Exactly, and we find that it's almost like more and more we have overlap in our discrete areas. Now, regarding questions, if you have questions that come up, we are going to answer questions at the end, so feel free to use the chat box and put a question in there, and after the last slide we'll go through and see what type of questions everybody has. Now today we do have a little agenda. We're going to cover 4 general areas. First of all, the end of the public health emergency and what impact that has on your lives. Then the impact of the end of the national emergency, the 60-day outbreak period. And then we're going to do a compliance review. And finally, at the end, I'm going to do what I've called the HR crystal ball. We have a lot of things in the world of HR that are kind of, I hate to, it sounds negative to say hanging over our heads, but just quite a few HR matters that are up in the air right now. And I thought I'd share and go over those with you and kind of talk about where I think things are headed. So those are the 4 general areas that we're going to cover. Now, the first thing that we're going to talk about is kind of a recap of where have we been the last 3 years? What kind of situation have we been living under? And it occurred to me not long ago that 3 years is really a long time. We've had a whole generation, I think they call them Gen Z, that have entered the workforce, and they really don't know any other world other than what we've been living under for the past 3 years, because these are folks that entered the work world in about the past 3 years. So in addition to work from home, which really is not a part of our talk at all, but a fact of life for so many people, we've also had these COVID rules that have been in effect, and that these are now subject to change, and some of them are absolutely going to change. So, we're all used to free COVID vaccines anytime, anywhere. You never had to pay for them. We're used to free COVID tests. You just go online, or you talk to your health plan, or you somehow you go into a store and you find free COVID tests. We've also had what we call the optional telehealth safe harbor, which has permitted first dollar benefits for individuals enrolled in high deductible health plans. You know how you normally have to fulfill your deductible for anything other than preventive services before you actually receive a benefit that's waived for telehealth during this period. Also, more robust COVID services offered through your employee assistance plan without complicating the status of the employee assistance plan, without taking away the accepted benefits that they've been operating under. COVID services provided at no cost have not affected mental health parity rules, mental health parity rules where mental health and physical health have to be covered similarly. Extended timelines for COBRA, HIPAA special enrollment, and external review. All of those things have been part of our COVID world. And now a lot of that is changing. So here we go. We're going to talk about these changes. The first thing, you may have heard me talk about the national emergency and the public health emergency just a minute ago. As we were preparing for these slides, honestly, this kind of dawned on me for the first time. We've been operating under these kind of parallel emergencies that have been out there, two different things that really have two separate domains that they've affected. So the national emergency started in March of 2020 and ended April 10th of 2023. And Corbin is going to go into detail on how and what that has affected and will continue to affect. And the public health emergency started in January of 2020 and it ends on May 11th of 2023. So we're going to go into detail about how the end of these eras is going to affect us henceforth. So first, we're going to talk about the end of the public health emergency. All right, so what does this mean? Now, this could have meaning, a lot of meaning for you as employers, because certainly if there's been one thing that's been in the news a lot for the past at least 2.5 years, it's been COVID vaccines. And here's the post-public health emergency impact. So effective May the 12th, the switch is pretty much going to flip, and COVID vaccines that have been free anytime, anywhere are no longer going to be absolutely without cost to your employees. So as long as your employees receive their vaccines in network per the Affordable Care Act requirements, those are going to be covered as preventive services, which means there's going to be no cost sharing. So your employees are going to need to go in network to get free vaccines. If they are provided out of your health plan network, then the health plan may require cost sharing, some type of prior authorizations, any type of medical management, and that sort of thing. So that's something that I would encourage you to communicate to your employees how this is going to change after May the 12th. All right. Now, also in the news regarding vaccines, this has kind of slowed down or actually come to a halt recently, the employer mandated vaccines. You probably remember 6 months ago, we were still talking about various groups that might be subject to required vaccines. Well, the EEOC says that yes, you can still mandate vaccines in your workplace. All right, so there's nothing illegal about an employer mandating vaccines, but you do have to keep in mind that you need to comply with the rules for accommodating religious and disability exceptions. So I'm sure that many of you have encountered employees who have resisted getting vaccines for a couple of reasons. And so be aware that that although you may require the vaccines, you do still have to accommodate religious and disability exceptions. However, the CMS vaccine mandate for employees in the healthcare realm, that is still in effect. So those employees, I think there's a list of about 17 different types of medical facilities where those employees still must be vaccinated. So those are the things that are not affected by the end of the public health emergency. All right, now we move on to COVID testing. All right, so after the PHE, health plans may but won't be required to place cost sharing, prior authorization, and other medical management requirements on coverage for COVID-19 diagnostic testing. So again, your employees will no longer be able to order by mail or necessarily be able to order by mail, certainly not pick them up free in a store or reimbursable in a store. The plan may continue to do so, but that's going to be a per plan decision, and that's one of those things that is, may be subject to change. But for right now, just be aware that your employees could incur costs if they try to get COVID tests. Sorry about that. All right, and I'm going to turn the process over to Corbin. Corbin's going to take the wheel, and
thank you, Barbara.
Thank you.
Yeah, so we've covered vaccine. So in network will be covered just like any other preventive care, and out of network, and again, no free COVID tests.
The end of the free lunch.
In the end of the free lunch. It doesn't mean if you still send out to the CDC, I imagine as long as they have them, they'll probably send them out no cost, but there really is no guarantee that it's free anymore.
Right.
And so in order to accommodate a lot of these services during the past 3 years that applied to COVID, it actually required health plan rules. I think of it as being broken during the PHE, because each of these benefits listed below, telehealth, what's called an accepted employee assistance plan, and mental health parity rules, have certain rules that were impacted by covering COVID vaccines and testing with no cost share. And so after the public health emergency on May 12th, they're going to revert back to pre-pandemic requirements. Now, that said, telehealth during COVID, there was always an optional telehealth safe harbor, which meant that individuals with a high deductible health plan could use telehealth services before they met the minimum deductible. So that may have been with a minimal cost share or no cost share, but it didn't disallow individuals from contributing to their HSA. Normally, if you have a high deductible health plan, you have to meet the minimum deductible, except for preventive care, in order for that plan to be what we call qualified and allowing individuals to contribute to their HSA. The problem, as we all remember, is that really you couldn't even visit your doctor in person. So it was very difficult, and telehealth was the way to go in most instances. And many individuals do have high deductible health plans and contribute to their HSA. So they did open up this optional telehealth safe harbor that you may have utilized in order to allow individuals to contribute to their HSA. Now that started in January 1 of 2020, and it was renewed again in April 1, 2022. And if you'd like to continue this, if your carrier offers it, or if you'd like to continue it with your TPA on your plan, then you can for plan years up to those beginning on or after January 1, 2025. Now, with that said, there is movement legislatively to have this become a permanent safe harbor. So that also may change, but that's where we stand on that today. Also, post-public health emergency, there are these plans called accepted employee assistance plans. And it's not like, I'll just use you, Barbara. It's not like I accept you. It's like accept Barbara, right?
I'm no longer exceptional.
No, that's right. You're always exceptional. So there are certain employee assistance plans that they don't really provide medical benefits, right? So this is a type of employee assistance plan that might provide a referral to a doctor, but it doesn't actually cover office visits or cover, a couple of free visits for you or your family members for going through a situation. Those plans, the ones that do cover the medical benefits or offer those visits, make the EAP, the employee assistance plan, it then is required, it's considered really like a group health plan, and so it's subject to COBRA, and that's the important thing here. Well, during the public health emergency, again, we were covering testing and other services related to COVID-19 with absolutely no cost share. And so if you had one of these types of accepted employee assistance plan, normally that would turn it into a group health plan and make it subject to COBRA. But again, they broke the rule there and said, no, you can cover these services without cost sharing, without creating a group health plan. So moving forward, if you have this type of employee assistance plan, you feel free to check with the provider or the carrier if the plan's going to continue to cover COVID-19 benefits. Because if it does, then it has to do it in a way that doesn't jeopardize their accepted benefit status. Now, all that said, I think in reality, they're just going to go back to pre-public health emergency because they're not going to offer something that's going to jeopardize that status. I would say by and large, the employee assistance plans that are out there today really are more like group health plans and do cover the visits. So this is one of these little minutia instances that I love to talk about in compliance. The last thing we'll talk about here is the Mental Health Parity. The Mental Health Parity and Addiction Equity Act was passed in 2008. And I think it's an incredible law because what it does is it prohibits group health plans from restricting mental health and addiction benefits. So that results in the individual getting a lower level of coverage or has what we call non-quantitative treatment limits that are less than what they would have gotten for a medical or surgical benefit. So for example, some person having to go inpatient for psychological care, there has to be some level of parity with what would happen if they went into the hospital for surgery. And group health plans actually test their plans every year to prove that the mental health benefits are on par with medical benefits. So for all your fully insured plans out there, the carriers test them. Most of the TPAs do it for self-funded plans. However, sometimes you have to use an outside contractor to do it. But that's called a non-quantitative treatment limit. I really didn't bother to spell it out because I'm sure you don't really want to put that on the tip of your tongue every day. But just know if that request ever comes from the Department of Labor, that's what it is. And so during the public health emergency, health plans, again, were allowed to cover COVID-19 testing and services without cost sharing. So this is the theme. So what does that mean? That means the health plan is now providing a much higher level of service for medical than it is for mental health and addiction. So as of May 12th, plans can't cover the testing and services in a way that results in greater benefits being given to medical and surgical versus mental health and addiction. But since there's no requirement either for plans to cover COVID testing, really, I think it's going to revert back to the pre-public health emergency instance. But just be aware, in case you weren't aware, that this is actually a law that's been around since 2008. So we're going to skip gears a little bit, and now we're going to talk about the end of the national emergency. Actually, it already ended. President Biden signed legislation that passed ending the national emergency April 10th, 2023. And unlike the public health emergency, benefits or provisions under the national emergency just don't go away on April 11th. There's an extension of time. And the reason for that is during the national emergency, additional time was given for health plans to put out notifications, right? If you had to amend your plan document for different things or, things changed in the plan, you couldn't get them out in these short time frames. And also, and more importantly, if you had a participant that needed to have a HIPAA special enrollment or to have a health plan decision appealed to an independent TPA, or importantly, COBRA, it may have been difficult to meet those timelines. So those timelines are usually around 30, 60, or 45 days. And so those were all extended out greatly. And the extension of these timelines is referred to as tolling. It would probably be simpler to call it an extension.
Right.
But they just, we settled on the word tolling. So tolling, what tolling has done is it's created an individual time frame for each person. So if someone, for instance, I mentioned HIPAA special enrollment. So normally under a HIPAA special enrollment, let's say someone had a baby, you would have 30 days to put that infant on the coverage. Well, during this period of time, you actually have a year from the date they're first eligible, or something called 60 days after the end of the outbreak period. So it would be a year from when the person was first eligible on or after March 1st, 2020. So if it happened in 2020 or 2021, the year has expired. So now individuals would be included, it would be the 60 days after the end of the outbreak period. So again, you have the national emergency, then you have this period called the outbreak period, and then 60 days after everything ends. And the reason for that is, again, people have been living under these long timelines, and they want to make sure if anyone's impacted that they have the ability to make that decision. So let me give you an example. Let's say someone was a COBRA qualified beneficiary, and they were supposed to make their COBRA election by June 1 of 2022. Okay, so this deadline is going to be tolled to June 1, 2023, except the national emergency ended before June 1, 2023. So this person will have 60 days from the end of the outbreak period to make the decision to make an election. And in this example, the new COBRA deadline would be 60 days after June 9th. June 9th is the end of the outbreak period. And so that would give them August 8th. If this sounds confusing, it actually is confusing, and it's not something you need to remember. And you may also think, well, who would go back a year to pay COBRA premiums? And that's a valid point. But let's say, for example, someone is eligible for COBRA and they go about 6 months and they never elected COBRA. But then they're in a horrible accident or, have a terrible diagnosis and they incur $500,000 in medical claims. In that case, during the national emergency, that individual could go back to June 1 of 2022, 6 months later, pay the first premium or pay all the back premiums and have coverage. So it's not something that was likely to have happened, but I'm sure it did happen during the emergency.
Now, during that period, would the insurance company be paying their claims?
Correct. They would not be paying their claims. And so in addition to that, let's say you had elected it, then you had a year after your 45 days. So then you had another timeline. But again, nobody has to, the carriers would just pause payment on anything until you were up to speed.
Right.
So, because what they didn't want people not paying and then getting all of these expenses paid and then never go back and pay the premium.
So the bottom line is you have to pay your premiums in order to
bottom line is you have to pay your premiums. That's right. Yeah. Now we have not experienced this at Beneflex, but I'm sure somewhere across the country there have been a couple of instances where it benefited people. And that was a good thing because the national emergency wasn't a great time for us. So what is your responsibility to your employees? And really, even though you're not required to notify your employees about the end of the national emergency, I think we feel it's very good that you communicate generally to employees about the end of it and then the associated changes. They're going to have to pay cost sharing for COVID tests out of network. Cost sharing for COVID tests. They'll have to have cost sharing for COVID-19 vaccines if that's administered out of network, et cetera. If your plan went to the extent of amending the plan document or the summary plan description to put these COVID-19 changes in there, then you have to amend it back and issue a summary of material modification. That is probably the exception, not the norm. Because we were working under emergency provisions, I doubt that many plans amended for COVID-19. Now, it also says notify participants of the end of suspended timeframes. Well, of course, you're not going to know who's in a HIPAA special enrollment or who's in a deadline for an external review. So again, I think in any communication, it would just be a general notification that any extension of timelines is going to revert back to the normal level. You don't need to get into great detail, but everybody always wants everything for free, and it's always nice to let people know that it's not going to be free necessarily any longer. If you have another COBRA administrator besides Beneflex, you might want to ask them, did they send out personal letters to qualified beneficiaries indicating all of these different timelines to them personally? We did not do that. We had an insert that we put in the COBRA letter. We didn't change the Department of Labor COBRA letter. And thankfully, then we don't have to go back to all of those individuals. But so if you used another COBRA administrator, you could check with them to see if there's any implication for them. And so briefly here, before I turn it over back to Barbara, who's going to see into the future.
Yes, the crystal ball, getting it polished up here.
That's right. We have a couple of compliance updates about in 2023. Under what we call the Transparency and Coverage Rules and the CARES Act, that was probably the most significant amount of legislation and rulemaking impacting employee benefit plans since the Affordable Care Act. And the timelines of all the different new requirements are also funneled out over different years. And so we want to talk about two of them, the RxDC Reporting and the Gag Clauses that are directly related to the CARES Act. So RxDC, what does that mean? Rx means prescription, DC means data collection. And so by June 1 every year, health plans and issuers must provide certain prescription drug information to CMS. Basically, they want to know what's the plan spending on prescriptions? What drugs are accounting for the most spending? What are the rebates from manufacturers? And quite frankly, I think that could be some very helpful information to get that rebate information out there. And so that's going to be sent to CMS through an online portal. They call it D1 through D8. And the important thing about this report is if you're fully insured, I believe all the carriers are doing this on your behalf because they have the data. Same thing with your TPA. However, we do know that certain carriers sent out surveys to some employer groups out there. They did not, unfortunately, inform individual brokers of who got these surveys and wouldn't release that information. So we don't actually know, perhaps if you missed a survey that came through, this is an awkward situation because normally we would be told that information, but we actually don't have access to it. So if you have a question or a concern or you remember getting a survey, you can reach out to the carrier, or you could actually reach out to your broker and just have them check for you. There is a penalty. It's $100 per affected individual. However, this is so new. It's very complicated information. Even though they have a penalty, it doesn't mean that penalty is ever going to be imposed. We simply don't know.
This is kind of an under the radar
situation. Yes, and actually the first reporting was done by January 31st of this year for 2021 and 2022, but there was safe harbor that applied. So the carriers didn't actually submit some information. And so some of the carriers need information that comes directly from the client, like their Form 5500 number and stuff like that. It goes into a section called D1. So I just want to point that out and expect to see that moving forward. That's what that means. It's an annual report that goes to CMS. And if you happen to maintain 2 plans through the calendar year, so let's say you had non-calendar year plans and different carriers, then they will both report. So you might want to check on that. hopefully as it moves forward, I hate to say to somebody, maybe you should check, but this is such a new provision and we just unfortunately don't have access to all the information for that. Now, this is called a Gag Clause Attestation. Again, prior to the CARES Act, plans could contract with providers, hospitals, where the information was restricted. Like it literally was illegal for the provider to tell a consumer what their reimbursement rate was from that carrier. And the reason is they wanted to keep their rates competitive. Now, this creates a great disparity in price across the healthcare land. And so it is now illegal for any plan or any provider to get into arrangement where they have that gag clause, where the provider price and their quality and even looking at de-identified claims is not allowed. So in the long run, this should actually be a very good thing for the industry. I often think of it like the grocery store. So you go into the grocery store and you can see the price per ounce, and then that leads you to what the retail price is. So if you're putting pressure on providers by making all of those prices transparent, the idea is that the market is going to push the prices down so that it'll be much more competitive and they'll be in line. The reason we're bringing it up is you have to submit, and actually I'm sure it's going to be the issuer, the TPA, because they do the contracts. They have to submit their Gag Clause Attestation to CMS by December 31st of 2023. And same thing, they just go on to an online portal and answer a couple of questions. We mention it because go ahead, I hope all of you get our newsletters, look for information about that moving forward. We just want you to be aware that that's one of the new provisions and you might see something on that. Plus, it sounds so fancy, gag clause.
Actually, it sounds like something in a big trial.
Yeah, exactly. That's right. All right, lastly, and then I'm going to turn it back to Barbara, are some changes to 1094, 1095B and C reporting. So ever since the Affordable Care Act, if you have a self-funded or a level-funded plan, you as the employer must report to the individuals using a 1095B that they had coverage, and then file those 1095Bs along with the 1094B to the IRS. If you're an applicable large employer, 50 or more full-time employees or equivalents, you're also required to report full-time employees, whether they had an offer of coverage, whether it was affordable or minimum value, using a different form with the same numbers. It's a 1094 and a 1095C. And then you must complete part 3 if you had a self-funded plan. That way, a large employer with a self-funded plan didn't have to do B forms and C forms. Now, up until this year, those forms did not have to be filed electronically unless you issued 250 or more returns. But now it's going down to 10 returns. So most applicable large employers probably are filing electronically. If you are filing in paper, just know that for this upcoming year, filing year, it has to be filed electronically. If you have a self-funded or a level-funded plan, the majority of those clients have always filed them on paper, but they need to be filed electronically. Now, you can go on the IRS website and request the TIC code, which will allow you to file through the AIR system on these reports, or you could utilize a service to do that electronically for you. And we have a number of services out there that we can avail to you. But just keep in mind that if you have at least 10 W-2s, and you might say, well, I only have 10 employees and we're on a self-funded plan. But if you have one employee quit and another employee replace that employee, now you have 11, and it has to be filed electronically. So safe to say, everybody's going to have to file electronically.
Yeah, that seems like a big departure for really small employers.
Yes, it is really small employers, but okay, so I'm going to go ahead and turn it over to Barbara. And just so you know, we record all of our webinars, and this will be on our Towne Benefits site under news and webinars. So that's where we house all of our webinars. And I will send out the recording and a copy of the slides to everyone in a couple of days.
For remembering that. We have a shiny new website.
We have a shiny new website.
It's awesome, and it's TowneBenefits.com.
That's right, Towne with an E, benefits.com. It actually looks very great on your mobile app. So it's been, we really want to try to make it easy to find. That way, if you ever need to reach anybody, our names, our emails, everything is on there. So we hope you go check it out. And we like the fact that our newsletters and webinars are posted there. So you don't have to go through your emails and search through them anymore.
Yeah, it's impressive. The team who put that together deserves a serious kudos. Yes. All right, we're looking into the HR crystal ball. I've got several things that have kind of been floating around out there. And as I've worked through creating these slides, I've realized really how far-reaching the pandemic has been. A couple of these things would never probably have not even ever have come up if it hadn't been kind of the unanticipated consequences of a pandemic. And I'm guessing that none of these things will apply to everybody who's listening today, but some of them might. And most of these things, you don't have to do anything at this moment. I'm just putting these out there, putting them on your radar so that you can be aware if you hear more about these issues, and if they do affect you, at least you sort of know that they're out there. Okay. The first thing that we're going to talk about for a minute is exempt pay and definitions of exempt employees. I'm sure that some of you have heard about this, that the Department of Labor for a while has been talking about increasing the weekly minimum pay of exempt employees. I believe this was last increased within the last 10 years, I think. It used to be very low, and now it's $684 a week. So if you have someone classified as exempt, you have two tests that you have to meet. One is the salary test, and the other is the duties test. So this minimum salary that you have to pay exempt employees, which means you are not required to pay these employees overtime, even if they work over 40 hours a week. Right now, it is $684. So that is subject to DOL discussion and possible increase sometime in 2023. The Overtime Pay Act was introduced on March 29th. Now, this act does not apparently stand much chance of passing, but it's worth it, at least for you to see kind of how they're discussing things. This would raise the minimum salary for exempt employees in annual increments between 2023 and 2027. So again, just to be aware that that's out there. I'm probably thinking it's going to be more like just a flat out one-time increase until they review it again. Now, the second is going to be the potential for the DOL to adjust the exempt duties tests. I'm not sure exactly what they have in mind, but as most of you know, we think of exempt employees as being, more managerial, white collar, that sort of thing, and they have specific duties that they have to be involved in. So the DOL may end up changing those duties. My guess would be to make it slightly harder to put some people into the exempt category. Now, the DOL, they could do both of these things. They could do one out of two, or they could do nothing. So, we've been waiting and we're still waiting, and we'll see what develops in 2023. Second thing I want to talk about for a minute, and this has been driven indirectly by the pandemic, the redefinition of independent contractor versus employee. And I don't know how many of you out there actually utilize independent contractors, but we've, for a while, kind of been operating under the 6-factor test for determining independent contractor status. So things like how integral to your business is the work that this independent contractor performing, whether or not they have a profit ability. Are they able to how much control do they have over the profitability of what they're doing? the worker's skill, the worker's initiative, where the work is performed, how permanent is this relationship, and how much control do you have as the employer. And basically you kind of add all that up, look at the totality of the circumstances, and make the decision about whether this person is an independent contractor or an employee. Now, the reason this is being looked at is because independent contractors are self-employed, so they have to pay their own employment taxes rather than having an employer out there paying them. Also, independent contractors are not usually provided with any type of employee benefits, so health insurance and that sort of thing they have to find on their own. Nor are they protected by certain laws like FMLA. They don't have any type of job protection for family and medical leave. And so you can see kind of the good news and bad news for the two different sides here, the employer versus the independent contractor. For the employer, if they make it more difficult to classify people as independent contractors versus employees, then you can see where that's going to increase the cost for the employer, because now the employer has to take on the payroll taxes. The employer has to provide the same employee benefits that they would with other employees, and then you've got the protections, the FMLA, all the new person, the new now recently converted employee would now be entitled to all the other legal protections that other employees are provided with. So it's difficult to say how this is going to come out, but do be aware that it's out there, and that some people that you may be having a relationship with now that are independent contractors are now going to become employees. This whole discussion has been driven largely by the pandemic. So many people have gone to gig employment, and a lot of people like that gig employment. And so they, but they don't like the fact, that they are missing out on some things that employees are benefiting from. So that's the question is, which way is this going to land? Again, we could see nothing out there on this by the end of 2023, but on the other hand, it wouldn't surprise me to see the Department of Labor making some type of different rule that could impact you. Now, another thing that was impacted by the pandemic is your I-9 requirement. As you know, anyone who comes to work for your company has to prove that they're legally able to work in the United States. And so that's done via this I-9 form. The rules were changed during kind of like Corbin's section on the suspension of some of the rules. The I-9 rules were changed because of the pandemic, because it was impossible in some cases for an employer to physically examine these documents, and that was part of the requirement of the I-9 form, is that you had to physically look at their proof of eligibility to work in the United States. And so they were able to do it by fax, email, that sort of thing. Now that temporary rule, the flexibility rule, has been extended through July 31st of 2023. So right now we're still operating under that temporary rule that was less burdensome on the employer. And I think at one time it was announced that you'd have to go back to the old way of doing things on a specific date, which was shortly, mitigated, because a lot of employers were like, hold on, we still have people working remotely. It's still hard for us to examine these documents. And so that's when that extension was put into place. Now, here's the issue for the employer. That is, what happens if this rule is not made permanent? Then I'm quoting here on the slide directly from the Department of Homeland Security. Right now, the way it's written, when this temporary extension expires, is you're going to have to go back and now physically examine the documents within 3 business days for in-person physical verification of the identity of people that you hired during the emergency. And they say that you're encouraged to go ahead and start doing that if you can, in order not to have this huge backlog, and it's going to turn out to be basic impossibility of reviewing these documents within 3 business days. So hopefully, I think common sense will prevail and that they'll make these rules permanent. But, you know, again, it's the crystal ball. We really don't know. But hopefully we'll know before August the 1st about that extension or permanency of the flexible rules. Next, we're going to talk about non-compete agreements. Probably most employers do not use non-compete agreements, but certainly those in the high-tech industry are more prone to non-competes. And so what is it? A non-compete agreement is an agreement that the employer and the employee sign that basically limits what the employee can do as far as employment during some period of time after the employment ends. So it's going to be something like an agreement that says, you know, employee, you cannot work within a 100-mile radius of our office for a period of 2 years in a situation where you would be competing, you'd be in the same industry you're in and you'd be competing with our company. So that's kind of the gist of what a non-compete agreement is. And we know, why do employers require non-competes? Well, because they want to protect their the things that their business systems, their trade secrets, their intellectual property, and then they want to limit the ability of new competitors to come into the market, or for you to take all of the things that they've been doing since you've been working there and just take that knowledge and that information right to a new employer who can then use your own methods and your own ways of doing business against you, basically. And so that's why that's the issue with non-competes. So there's been a lot of questions about how fair is it to tie employees' hands and not enable them to seek employment in their industry for this, time period. And so the new rule is going to make it much harder or impossible for employers to require non-competes. Basically, we swing from one extreme kind of to another, where this FTC rule would say you cannot enter into or attempt to enter into a non-compete agreement with a worker. You can't maintain a non-compete with a worker, nor can you represent to a worker under certain circumstances that the worker is subject to a non-compete. So it really takes non-competes for most purposes off the table altogether. Because again, it would include rescinding existing non-competes and actively informing workers that they're no longer in effect. Now, the proposed rule would generally not apply to non-disclosure agreements and agreements that protect trade secrets. So at least they've had the forethought to consider, what the impact would be on employers if suddenly there were no issues with trade secret sharing. Now, as with so many laws recently, when I came into the HR world, we operated in this federal law bubble mostly, where the federal law determined what the laws were going to be as far as employment goes. But now over the years, more and more things have been subject to the states making their own laws, and that is true in the state of Virginia. Virginia actually has a blanket ban right now on non-competes. This is as of July 1st of 2020, with people under a certain wage threshold, and that wage threshold is subject to change every year. So for 2023, if you have employees making less than $69,836 a year, or $1,343 per week, you already cannot have a non-compete with anyone below those thresholds. So there may be some change with what the DOL specifies, which would be at the federal level, but already you're limited as far as who you can have a non-compete with. Now, if the DOL comes out with a new threshold for the salary, let's just say, and says that anyone making less than $1,000 a week, you can't have a non-compete. Well, that doesn't have any impact at all on the Virginia law, because the Virginia law is already higher than that. So if whatever works to the greater advantage of your employees is going to be the law that prevails. So when we have conflicting Fed and state laws, whichever one the employee benefits from most is going to be the one that you're going to have to go by. Now, the final thing I want to talk to you about is a potential sea change in religious discrimination at work. I know in the last couple of days, I've actually seen more mainstream media coverage of this case that's currently before the Supreme Court. It is called the case of Groff versus DeJoy. And while a lot of times these Supreme Court changes don't come up with, decisions don't amount to much for on the employer side, this one does have some impact to potentially affect employers. That issue is an employee of the former employee of the U.S. Postal Service who did not want to work on Sundays. And so he ended up quitting his job after being penalized for refusing to work on Sundays. He sued his employer, and now this case, the Supreme Court has decided to take this case. So here's the crux of the issue. There is Title VII of the Civil Rights Act, which covers basically non-discrimination based on various characteristics. Religion is one of those characteristics. Now, in 1977, a case came before the Supreme Court similar to this, the Groff case, and it ended up that the Supreme Court at that time decided that the wording undue hardship, which is not defined in Title VII, it says that you can't discriminate on the basis of religion unless it causes if it causes an undue hardship on the employer. And so the Supreme Court in 77 put a very low bar definition on undue hardship. And so basically it was, if it's going to have a minimal impact on the employer or a minimal cost to the employer, that is going to be an undue hardship. So it was easy for employers to say, we're not going to accommodate your religious request because it's going to take more than a minimal cost to do so. So the current Supreme Court taking this case on could apply a stricter definition of undue hardship and raise that bar, meaning that you're going to have to go through a different process to decide if it's an undue hardship. Now, how does this affect you? If this, a lot of what I'm reading out there says that this court is going to rule in Groff's favor and is going to raise the bar for undue hardship. So here's the takeaway for employers kind of on a day-to-day basis and how you should think about this. So I would kind of keep my eyes and ears open on how the Groff comes out. Because what it has the potential to mean to you is that you're going to then start needing to take a more Americans with Disabilities Act approach to dealing with employee requests. And what that means is probably having to engage in what we call the interactive dialogue with the employee, talk about different types of reasonable accommodations, ask the employee, what are you requesting as a reasonable accommodation to your religious request? And then having these conversations with the employee to see if there's something that you can agree on. And then you're going to want to document this process. And if the request is denied, you're going to have to kind of want to substantiate the reason for the denial. What would it take? Why do we think it's an undue hardship and that sort of thing? And I can also see down the road, this is going to possibly mean more often you're going to want to talk to legal counsel before you refuse a request for a religious accommodation. So, again, we don't know how it's going to come out, but it is one of those things that has the potential to affect employers depending on how they rule. So that, in a nutshell, rounds out our HR crystal ball. Hopefully you found some of that helpful. And I'm going to put us up there, Corbin, with our names and our email addresses. You can always email us or contact us. And then we're going to go over to the questions. Let me see if I'm a good enough driver to get us back to see if we have any questions.
Stop that. I don't see any.
Maybe we don't have any questions. Maybe everybody is sitting in stunned silence.
Is that a good thing?
A good thing or a bad thing here? Yeah, let's just double check. Yeah, we don't have any questions.
Okay, well,
So I would say thank you very much for paying attention and for being here with us today. And if, as you go back through and think about what you've heard, or you go back through the slides once you get them and you say, whoa, wait a minute, what does this mean? You know, you can always contact Corbin or me at our email addresses or by phone. And I'm sorry we don't have our phone numbers on there. It seems like so much is done by email these days.
Right.
Feel free anytime. We always enjoy our interactions with our clients and just take a lot of satisfaction in feeling like we've been of help to you.
Should we announce our other news?
Oh my gosh, our other news. That usually means somebody's getting married or having a baby. And it's neither.
We're past all that.
That's right. And so Corbin, do you want to do the honors of talking about what's next on our horizon?
Sure. So really one of the things we're doing in addition to our website and our webinars is we've been putting together a host of podcast topics. And I do see that somebody did ask a question that I'll get to in just a second. And so we have been busily creating a new podcast. It's going to be called HR on Mic. It's very short snippets on particular topics like FMLA, dealing with difficult employees, qualifying events, harassment, retaliation, things that, you know, you don't really want to think about or take a lot of time, but maybe if you're walking your dog or something and you just want to get some information. I really love podcasts from different sources. So we're going to try to be pushing that out over the next couple of months, and we hope you enjoy it.
We're going to take about, you know, it's usually going to be maybe 15 minutes or less on one specific topic that you hopefully will a little bit deeper dive perhaps into the topics. But anyway, we look forward to rolling that out. We're excited.
Today. I think somebody said thank you very much.
Okay.
So, thank you. Right. Thank you all so much.
Thank you all for your attention.
It really is a privilege and a pleasure. And please have a wonderful afternoon. And we will be sending this out to you in the next couple of days.
We'll, yeah. Oh, and we got another piece of feedback on our podcast.
Oh,
so we're hopefully, we will be pushing that out to all of our clients as soon as we've got our first few episodes recorded. We're working away on it.
All right. Thank you so much.
Thank you.
Bye-bye.